Call the meeting to order. All three are present. It was properly posted on December 12th. Is there a motion to approve the minutes of November 10?
Unless there are changes, and move approval.
I second.
All in favor say aye.
Aye.
Is there a motion to approve the one item on the consent agenda?
I don't know whether it would be better to have the individual items that we're having under consideration decided first.
Okay,
There's any private entities
very good.
to be
Number three. This is about Diamond Ridge.
David Potts is here. He is not contagious.
I am.
Oh,
About
David can't make it. David's passing.
Oh, I'm sorry.
I'm Nick Tristan. So,
great.
You ready? Okay. This is a pretty simple issue. We just have to transfer between subsidiary and parent, and then the 5% cap was more than the 5% cap was assessed. So the value they put was what we got.
I wrote it down.
It was 351 and it went to 425. 425,000. The gross assessed value. So
You say because it was parent to sub that we should not have looked at
no, subsidiary to parent.
subsidiary.
Yeah, the law is clear on that. It in the Constitution, AB, it says where the 5% cap is, and then 682871.1 says you can't, if transfer to parent subsidiary is not a transfer for purposes of the 5%, or it excludes it. And this here's the deed showing the transfer. There's no doc stamps on it. So, I think it's a pretty simple.
Ms. Crawford?
Yes. It's our position that this board has no jurisdiction in the decision. And there is an AG's opinion on point 22. This is a BOE issue. And the highlighted red letter is there.
You already know.
And so it's pretty simple. Says if the actual fair cash value of a parcel increases more than 5% from the previous year, the taxpayer's first recourse is to an informal hearing before the assessor, and then they can go on to county board of equalization, and then of course on to district court. The Board of Tax Roll Corrections is strict. There are only 17 reasons where you can appear before this board, and 5% cap is not.
Did you try the other way that she's describing?
I can answer that.
It's not time for that yet, is it?
No, the deed was filed in 2022.
Oh.
We looked at the cap in 23. He's seeking a refund for 22 and 23.
It's 23 we want it corrected, and then 24 is the issue.
Yes,
The issue persists in the 20. They added on to the value of 2024.
And so they did get notice of increase in value that year, and they did have an informal hearing, and they didn't bring up this deed. And in looking at this deed, it's a special warranty deed, and the two names are very different. Summit Ridge Apartments to Diamond Ridge. So had they even raised the issue timely and in the correct year, they would have had to prove that point and just not make an assertion.
The point is that they have to have the same beneficiaries of the ownership. Is that correct?
Well, we would look at it on a case by case
Uh-huh.
basis, and without knowing the facts of this case,
It's
hazard to guess. But anyway, you don't even need to go there because TRC is not proper venue.
Do you agree, Madam DA?
I don't really have anything to add to this.
I think you're out of time. You do it the year that it occurred. I thought it just occurred. Now, I was going to tell you, wait till January. That's for the informal, then coming from. I'm on the board.
This was 23rd.
was 2024 as well.
Which you would have done last January.
Yeah, he would have gone to informal
Right.
and the BOE 2023.
Three.
It affected the year 2024. That's why he's trying this route as well. For 2024, that's why he has two petitions. But but it doesn't fit on the TRC statute.
Well, even if it did, it's out of time.
Okay. I took this over from someone else, so.
Motion to deny.
Okay, so you're saying it's not only out of time, it's wrong jurisdiction.
Correct.
Okay.
And I say,
How does it even get on the agenda if it's not eligible under those 17 reasons?
Well, it's a due process issue. If, we can't deny a taxpayer the right to come and complain, whether he be right or wrong. We just disagree and then put it on as a special item for the board to consider.
I didn't think anything could be on our agenda that we couldn't consider for legality and form.
Well, no. This is a quasi judicial. So if a taxpayer is wrong, he's entitled to come to find out he's wrong, not just somebody saying you can't appear before this board.
There's not a filing fee or anything. It's just a matter of showing up, correct?
Beg your pardon?
There's not a filing fee. It's an opportunity to be able
This
to
is a
resolve this.
request for an agenda.
So
Difficulty is getting noticed to the taxpayer.
it's not like a court, although the decisions are similar.
It is a quasi judicial, just like.
Okay. There's a motion and a second. Any other discussion? All in favor, say aye.
You okay?
Merry Christmas.
Merry Christmas to you.
When you get to number 4, I'd like to address.
Go ahead.
Number 4 is different.
Do we have a representative here for that?
The taxpayers,
Would you like to come up, sir?
but we're basically confessing this.
oh.
This is unusual. The TRC can hear issues when a taxpayer does not receive notice of increase in value. However, the statute said the taxpayer cannot provide evidence of that, which means that the assessor has to admit that they did not give notice. And admittedly, in this case, there's a clerical error, data entry, and that mailing address was incorrectly input. And this taxpayer did not get notice of increase in value, so he did not have an opportunity to do an informal or a formal before the BOE. However, the AG long ago has stated that the TRC cannot hear value issues. So the only way to get this taxpayer due process, and we've kind of pulled this from some advice from the Oakland Tax Commission long ago, would be to ask this board to make a factual determination that due to a clerical error, this taxpayer did not receive notice for the 2025 tax year. Refer the matter to the BOE in its next available meeting. Allow the BOE to hear his issues. I'm not saying we agree with them or disagree with them. It's just out there. And whatever the BOE decides, refer it back to the TRC. So in the event he prevails, the TRC could then legally adjust the tax roll. It's convoluted, it's circular, but it allows him due process.
You agree, Madam DA?
Yes.
All right, is there a motion?
Motion to
Oh,
approve.
I think
Sorry.
I'm seeing rumors.
No, I just, I'm on the Board of Equalization. No, I'm good.
Motion to approve.
Second.
Well, do you want to describe the motion, right?
Yes.
The motion would be, if you so find, that the assessor admits or asserts that improper notice was given for the 2025 increase in value, and thus is referring it to the BOE for a hearing. Now, I was asked, there's nothing that triggers it the informal, so it's going to jump a step.
After we meet in January. How will it get on our calendar?
We'll ask clerk to put it on the next BOE agenda.
Okay.
But I don't think you'll have any informal documents unless you all direct something to occur, but you might be hearing it on the fly.
That's your wheelhouse, not mine. Is there anything you need?
No. It shows up on the docket with the,
That will be my motion. That she just stated.
okay, the motion is to
Refer
admit
this-
that there was not a notice given to the taxpayer, therefore the matter should be referred to the Board of Equalization in its next meeting.
I think the word would be assert. Did you say assert?
First, confess.
Okay.
We can do a legal term. But we checked our records. It was better.
There's a motion to, there's a move to confess the lack of notice to the taxpayer so that the matter.
He's
may be-
already moved. So are you seconding or?
Well, he acted like we had to correct it. I second his motion.
Fantastic.
All right. Are you good with that? Okay. You're good with that?
Okay.
All right. All in favor, say aye.
Aye.
Now, do you want to return to item 2? Is it sufficient like that, or is there any redaction needed?
Unless there are any questions, we have to answer them. But other than that, I would urge approval of item 2, please.
A second.
All in favor, say aye.
Aye.
Any citizens to speak? Other than those already spoken, board comments?
Merry
New
Christmas.
I move that the meeting be adjourned.
So, second.
All in favor, say aye.
Aye.